Welcome back. Delhi High Court is set to pronounce order on Enforcement Directorate plea seeking a stay on the lower court order granting bail to Delhi Chief Minister Arvind Kejriwal in the money laundering case linked to the now scrapped Delhi excise scam. The High Court on Friday stayed the lower court order granting bail to Kejriwal, saying that the trial court order be not given effect till it hears ED's plea challenging the bail granted to him by the trial court on the 20th of June. A vacation bench of the High Court had said that it was reserving its order for 2 to 3 days as it wanted to go through the entire case records and had also asked the parties to file their written submissions by the 24th of June. The High Court also issued a notice to Kejriwal seeking his reply to the plea of the ED challenging the 20th of June order of the trial court granting him bail in the money laundering case. The ED moved the High Court against the trial court order, submitting that it was not given adequate opportunity by the trial court to argue its case and sought a stay on the bail order of the trial court. The ED during the proceedings before the High Court told the bench that the trial court order was one-sided and wrong-sided and that the findings of the trial court were based on irrelevant facts. The counsel representing Kejriwal vehemently opposed to the submissions of the ED and told the High Court that the ED argued for 3 hours and 45 minutes before the trial court and that Article 21, which amounts to protection of life and personal liberty of the Constitution, does not exist for the central agency for which the liberty of a person figured low in priority. Kejriwal also moved the Supreme Court against the High Court order and the Apex Court on Monday fixed 26th of June, that's tomorrow, for hearing his plea. A vacation bench comprising Justice Manoj Mishra and Justice S.V.N. Bhatti said that it would like to wait for the pronouncement of the order of the High Court in the matter. Trial court there, while granting regular bail to Kejriwal, said that prima facie guilt of Kejriwal was yet to be established and that the ED had failed to furnish direct evidence linking him to the proceeds of the crime in the excise policy-linked money laundering case. Let's go across to my colleague Nivriti Mohan, who joins us live from Delhi High Court. Nivriti, a very good afternoon to you. Any moment now, the Delhi HC will be pronouncing the order on the Enforcement Directorate plea, which sought a stay on the lower court order granting bail to Delhi Chief Minister Arvind Kejriwal. What's the latest you're picking up from the ground?
Good afternoon, Neha. Exactly, as you said that anytime the hearing can start, the court has assembled for the order on the bail plea of Arvind Kejriwal. Actually, the ED has filed a petition in the High Court after Arvind Kejriwal was granted regular bail in the lower court, that is Rouse Avenue Court, in the excise policy case. The ED submitting that the order was lopsided, it was one-sided, it was not given a chance, it was not heard, and it was not given a chance to present its arguments, and proper application of mind was not there by the lower court, and it submitted its written submissions in the High Court and against the bail, regular bail order that was granted by the lower court to Arvind Kejriwal. So it had come up with a petition and an application in the High Court against that order. And there is an order, although the High Court had granted an interim bail, interim stay on the bail granted to Arvind Kejriwal by the lower court, but it had also said that it will wait for a regular stay or to decide on the matter. It will wait, it will hear both the sides and then it will pass the order, although an interim stay on the bail was granted earlier. Now what is happening today is that court will hear the matter, it will hear both the sides, it will hear the Enforcement Directorate, and it has heard both of them, and now the order will be passed. And if Arvind Kejriwal's ED is if the interim stay continues, then then Arvind Kejriwal has already approached Supreme Court. The route of Supreme Court is open for him, and he will go to the Supreme Court where he will be heard. And the hearing is set to be there on 26th, that is tomorrow. But if the interim stay does not continue, that then he does not need to go to the Supreme Court, and he will go back to the Rouse Avenue Court, and after filing after filing all the relevant documents, he will be freed from jail. But now here in Delhi High Court, there is a hearing going on. There is an order awaited on the interim stay that has been granted to Arvind Kejriwal, and there is an order pending on the ED's petition against the order of the lower court, which grants regular bail to Arvind Kejriwal. So this is what is happening right now, and we are awaiting details from the court. So there is a detail coming in. Delhi High Court allows Enforcement Directorate's plea to stay the trial court's bail order for Arvind Kejriwal in the money laundering case linked to alleged money laundering excise scam. So Delhi High Court has allowed Enforcement Directorate's plea to stay the trial court's bail order. What does that mean? Delhi High Court has allowed Enforcement Directorate's plea to stay trial court's bail order. So the bail that was granted by the lower court in Rouse Avenue Court, the bail order, the regular bail was granted to Arvind Kejriwal. It has been rejected, and Delhi High Court has now allowed Enforcement Directorate's petition to stay trial court's bail order. That means
Right,
now Arvind Kejriwal
Nivriti, why don't you continue to stay with us? Let me, Nivriti, why don't you continue to stay with us? In fact, let me also break the news for all our viewers right on your screens. This is the big news that we're tracking for all of you. There's no relief for Arvind Kejriwal as of now, as the High Court has stayed Kejriwal's bail order. This is the big news that in fact we're tracking for all our viewers. The High Court, it's a big setback for Arvind Kejriwal. The High Court has accepted Enforcement Directorate's plea. It's a no relief for Arvind Kejriwal from the High Court. This simply means that Arvind Kejriwal will continue to remain in jail as of now. But do remember that in fact there is another hearing that is slated for tomorrow in the Supreme Court. But as of now, the High Court has accepted Enforcement Directorate's plea. It's a setback for Arvind Kejriwal. It means that Arvind Kejriwal will stay in jail for now. The Kejriwal, do you remember, has also moved the Supreme Court against the High Court order, and the Apex Court on Monday has fixed June 26 for hearing his plea. Nivriti, over to you. It's a big setback for Arvind Kejriwal. Do go on and tell us what does it really mean, and decode this particular judgment for us.
So once again, I must tell you what had happened. Initially, Arvind Kejriwal got arrested in March, and after so many summons, a series of summons, he did not surrender to the ED, and he finally got arrested in March, after which he was also released on bail during the election season on the condition that he will again surrender. Now, after surrendering in the Rouse Avenue Court on Thursday, he was granted regular bail, and on this regular bail, ED had approached High Court against this regular bail and said that it was not given a chance to be heard. It was not given a chance to be heard. It was not heard properly. And the order of the Rouse Avenue Court, the trial court, which granted regular bail to Arvind Kejriwal, it was one-sided, lopsided, because it was not given an opportunity to be heard. And its case was not heard properly. And the court, the lower court, learned court, did not apply its full mind in deciding what it has decided in granting regular bail to Arvind Kejriwal. So ED had given these written submissions in Delhi High Court. After which, today, when the bench sat and passed its order, it clearly said that it allowed Enforcement Directorate's plea, and the bail which was granted in the lower court, against which ED had approached the High Court. So the interim bail order was in a way rejected, and Arvind Kejriwal did not get any relief from the Delhi High Court. After, I must tell you that after interim stay was granted in Delhi High Court, Arvind Kejriwal's counsel had approached Supreme Court, and Supreme Court had put the matter for 26th of June, that is tomorrow. Supreme Court, although had said that High Court's order is unusual, it has found High Court's order to be unusual, but it has also made its intention. The Supreme Court has made its intention clear that it will wait for the order of the High Court, and then it will hear Arvind Kejriwal's plea. Now, because no relief has been granted in the High Court to Arvind Kejriwal, the matter stands in Supreme Court, and it will be heard tomorrow. That is on 26th of June in Supreme Court, and let's see what Supreme Court has to say on this and has to decide on this. The entire matter is of excise policy case, Delhi government's excise policy case, during which there were accusations of irregularities posed on the government. Manish Sisodia was also arrested in this matter, and then there were a series of arrests from the government made by the Enforcement Directorate. There were accusations of irregularities in the liquor policy case, and Arvind Kejriwal was also summoned in this matter by Enforcement Directorate repeatedly, to which he did not respond at all. Which resulted in arrest of Arvind Kejriwal in March, and in the election season he got out of the jail. He got the bail also, and then on the condition that he will surrender. He surrendered later and approached the lower court, the Rouse Avenue Court, where he approached the court and sought bail for himself. The regular bail was granted by the lower court, but the ED approached High Court, where ED approached High Court against the regular bail order. As I said, ED's point was that it was not given an opportunity to be heard. It was not given time so that it can produce its arguments properly in the court, and the trial court's order was lopsided, it was one-sided, it was misleading, and it was misrepresenting. That is what was given in written submissions to High Court by the Enforcement Directorate. And now, after this order, where Arvind Kejriwal has not got relief in the High Court, although Arvind Kejriwal's counsel in High Court had said...
That was my colleague Nivriti. In fact, she'll continue to bring us the latest from the ground. Meanwhile, I'm also joined by my colleague Ashok Bagaria in the studio. Ashok, this is a big setback for Arvind Kejriwal. The High Court, in fact, has here stayed Kejriwal's bail order. Do go on and decode this particular order for us.
Well, what this order really means is that Arvind Kejriwal will continue to be in Tihar jail despite a bail order in his favor from the trial court. Now, what it really transpired was on June 20th, Arvind Kejriwal was granted regular bail by the trial court, and ED rushed to the Delhi High Court filing an application seeking to put his release on hold. And subsequently, they also filed a main petition challenging the merits of the judgment, bail judgment, which was delivered by the trial court. Now, on June 21st, what happened was, when the matter was called out before the Delhi High Court put on hold Arvind Kejriwal's release from jail and said that it will be passing a verdict in 3-4 days' time, which has happened today. And the Delhi High Court has said that the findings of the trial court in granting bail to Arvind Kejriwal are wrong. So primarily, the Delhi High Court has come to two conclusions. Number one, it has said that the trial court did not go through the documents that were produced by the ED before the court, and the observation of the trial court in its judgment that it was not necessary to go through the bulky documents at this point in time was incorrect, and it meant that the court had not adequately dealt with the documents and records that were produced before it, number one. Number two, the High Court has also come to a conclusion that Enforcement Directorate wasn't given adequate and fair opportunity of opposing the bail granted to Arvind Kejriwal, because the hearing lasted for 5 hours and only 2.5 hours were given to Enforcement Directorate to argue its case. So on these grounds, the Delhi High Court has come to a prima facie conclusion that the bail order granted by the trial court is wrong and it needs to be stayed. Arvind Kejriwal, despite having a bail judgment in his favor, will not walk out from Tihar jail. Now, tomorrow, what is going to happen is that this matter is again in the Supreme Court, where Arvind Kejriwal has challenged this hearing before the Delhi High Court, saying that this is an extraordinary hearing. There is no provision in law for such an interim stay on bail because, number one, he is not a terrorist and no prejudice would have been caused if Arvind Kejriwal would have been set free. So tomorrow it will be a very interesting hearing in the Supreme Court, where Arvind Kejriwal's lawyers will be arguing strongly, saying that, look, that the Delhi High Court has delivered an order, passed an order, made some comments with respects to the merits of the judgment, and such was uncalled for. And what is interesting, Neha, at this point in time is that on Monday, when the Supreme Court heard this Kejriwal's application, the judges who were hearing this matter, Supreme Court judges, said that this kind of a hearing being conducted by the High Court was highly
let's listen to what he's saying. So what order has been passed by the High Court? So today, sir,
the High Court has appreciated our arguments and has stayed order of bail in favor of Mr. Kejriwal.
So what are the observations made by the High Court bench, sir, on your application?
There are several observations made, one regarding section
What about
45,
section 45?
45 having not been considered properly, and other is that the papers which were submitted have not been perused by the court. That's it, please. क्या कर रहे हो आप?
Okay. हो गया हटो
बार
आइए सर आइए
नहीं बार चलो आगे जान आप थे ना
did not appreciate the material placed on record by the ED.
yes you were present when the order was read. Hello बाहर आने चलो
It's a huge setback for Arvind Kejriwal from the High Court. The Delhi High Court has stayed the regular bail granted by trial court to Chief Minister Arvind Kejriwal in the excise policy case. A single judge bench of Justice Sudhir Kumar Jain passed the order while hearing the ED's application seeking stay of trial court order which had granted bail to Arvind Kejriwal on the 20th of June in connection with the money laundering case linked to the now scrapped Delhi excise scam. Let's go back to my colleague Ashok, who continues to be with us in the studio. Ashok, do go on and share with us some of the observations that, in fact, in the court.
Well, there were two, or rather there were a couple of observations made by the Delhi High Court, which actually impinges on the merits of the case. So first thing, the Delhi High Court, this is again a vacation bench, and it was presided over by single judge Sudhir Kumar Jain, who has come to a conclusion that there are reasons that the trial court order granting bail and directing the release of Arvind Kejriwal from Tihar jail needs to be stayed. In his order, he pointed out that there were 3-4 major flaws with the bail order. The first flaw was with respect to non-consideration of the documents placed before the court by the Enforcement Directorate. The second flaw was the court did not give adequate and fair opportunity to the Enforcement Directorate to argue its case or oppose the bail to Arvind Kejriwal, because Section 45 of the Prevention of Money Laundering Act says that as far as bail of an accused is concerned, it can only be considered by the trial court if the public prosecutor is given an adequate opportunity to oppose it. The third thing that the court has said was that there have been various orders of the higher courts which have gone into the merits of the case, and that precedence had not been followed by the trial court in setting Arvind Kejriwal free. The court has also dismissed the argument of Mr. Singhvi, who appears for Arvind Kejriwal, saying that this is more a question of personal liberty than anything else. The court on this point said that this is a matter which should be adjudicated by the regular bench of the High Court, which will look into the merits of the case. So these are some of the arguments which were made by the High Court upholding its stay on Arvind Kejriwal's release from jail.
Right, thank you. In fact, Ashok, for sharing these insights with us. Continue to stay with us. These were some of the observations made by the Delhi High Court. We slip it a quick break now, but we continue tracking this particular development for all our viewers. Don't go anywhere.